Ranjana Singh, on behalf of Adhivakta Parishad Supreme Court Unit, welcome you all to the fourth online session of Justice S. Parvatha Rao lecture series on the topic, which is quite relevant and thought-provoking, of foreign law as a kill switch. Does India need an AI lawfare doctrine? Adhivakta Parishad Supreme Court Unit has been organizing this online lecture series in the remembrance of the great visionary and legal luminary, Honorable Justice late Shri S. Parvatha Raoji, who was not only a great lawyer and judge and a human being, but also was a great pillar of strength to the Parishad. Before we proceed with our today's online session, I request Aditya Kashyap ji to kindly tell us about Adhivakta Parishad.
Namaskar. Thank you, Ranjana ji, for inviting me. I hope I am audible.
Yes, you're audible.
Akhil Bharatiya Adhivakta Parishad is an all-India organization of lawyers. Adhivakta being the Sanskrit word for advocate. So what began in 1992 as a seed now has grown into a large banyan tree, sort of. That was an idea to bring together advocates and their organizations across the country, even predating back to the emergency period and all the struggles that followed under one umbrella. And today we have our roots and branches from Kashmir to Kanyakumari and from Kamrup to Kutch. So from the Supreme Court to every High Court bench, across 46 state units, 600 district court units, 12 tribunal units, and down to the taluka level, our presence is marked across the length and breadth of this nation. Our motto is simple, Nyaya Mam Dharma, meaning thereby justice is my dharma. So Swami Vivekananda used to say that I call every man a traitor who, having been educated at the expense of the downtrodden, pays not the least heed to them. This conscience is what animates this Parishad. So we are inspired by service to nation, service to mankind, and especially to the downtrodden, to the last person in the society. The Parishad was born out of an urgent need to inculcate the nationalistic spirit amongst lawyers, while sharpening their professional skill as well. So advocates are catalysts of change, and we help society modulate its movement, address its aspirations, and address its apprehensions as well, all within the constitutional framework. So when this noble work is flavored with idealism and patriotism, it becomes a force for social upliftment and national resurgence. So for 30 years now, since its inception, lawyers affiliated with us have fought hundreds of cases from tehsil courts, trial courts to the Supreme Court on behalf of Vanavasis, the tribals, fishermen, street vendors, temple committees, animal welfare bodies, and farmers. In this, we have drawn steady guidance from our senior members of the bar, the bench, and social organizations working at the grassroots. Friends, let me tell you briefly how we work. So we run study circles where advocates across generations meet to discuss contemporary legal and policy developments that shape our society. I'm told that nearly 600 such study circles are functional today. We run Nyaya Kendras, free legal aid camps, especially in the remote villages and slums, going to the poor and the deprived, listening to them and helping them find a remedy to their issues. We also hold various workshops, seminars, and symposiums from time to time to enhance the skills of the advocates. We have built an interface where social organizations, advocates, academicians, they come together to make the legal system more effective, more people-friendly, speedier, and cost-effective as well. We believe that through the inculcation and channelization of what we call Sajjan Shakti, the strength of positive forces of the society, we can contribute to national policy as well as to the lawmaking process. We also published a quarterly journal named as Nyaya Prava, which deals with various socio-legal issues contributed to by judges, advocates, academicians, and students, and which has a readership going in tens of thousands across the country. Friends, at the heart of everything is one commitment that justice must be accessible, available, and affordable to the last person standing at the far end of the society. We have pressed adequate judicial infrastructure in our district and taluka courts, championed the participation of women in the bar and the bench, as well as a safe and congenial environment for them in our courts. And we are steadily working towards even the decolonization of Indian legal system. On each of these, we have begun the conversation, passed resolutions, and carried the issues to those who can act on them. So today, the Adhivakta Parishad extends a simple invitation to every advocate and every esteemed member of the legal fraternity present here. Come, connect and contribute to the cause of justice. Thank you. Namaskar.
Thank you, Aditya-ji. Before we proceed further with our today's online session and passing on to our esteemed speaker, Shri Gagan Gupta, Sir, Senior Advocate, Supreme Court of India, I would like to briefly introduce today's topic, which is not only contemporary, but is equally intricate and nuanced. We are living in an era where software code and geopolitical strategies are deeply intertwined. Today, we would address a highly critical and intricate issue, that is foreign law as a kill switch. Does India need an AI lawfare doctrine? And to be more precise, whether India requires a formal legal doctrine to safeguard its digital sovereignty. Before passing on to our esteemed speaker, I would request Shubham Shukla ji to kindly give a brief introduction about Sir. Over to Shubham Shukla ji.
It is my privilege and honor to introduce our distinguished speaker for the day, Sri Gagan Gupta ji, Senior Advocate, Supreme Court of India. Sir completed his BA Honours in Political Science from Sri Venkateswar College, University of Delhi, and then he pursued his LLB from Campus Law Center, Delhi. Thereafter, he commenced his legal practice before the Supreme Court of India in the year 2000 and became an advocate on record, securing prestigious second rank in the examination in 2006 and 7. Then he was also designated as senior advocate in 2024 by the Honorable Supreme Court of India. With more than 25 years of distinguished practice, he has appeared before the Honorable Supreme Court, NCDRC, Delhi High Court, and various other judicial forums. His practice spans a wide range of areas, including constitutional law, commercial arbitration, intellectual property law, succession law, and most importantly, some IT law as well. Over the course of his career, Sir has successfully argued numerous cases which have become landmark in a sense of jurisprudence, as well as they were reported by the honorable courts where those cases were argued, making signifying his contribution to several important areas of Indian law. His extensive courtroom experience, coupled with his deep understanding of diverse legal issues, has earned him widespread recognition professionally as well as a human being. We are truly honored to have you, sir, today. I'm confident that sir's vast experience and valuable perspectives will make this session both insightful and enriching. Please join me in extending a warm welcome to sir. Over to you, sir.
Thank you, Shubham, for a wonderful introduction. Thank you, Ranjana. Thank you, Jyoti and Aditya. Now, can I start the session now?
Please, sir.
Right. So, friends, at the outset, I convey my gratitude to the Supreme Court unit of the Adhivakta Parishad for having invited me to speak on this very contemporary subject matter. I also convey my gratitude to the distinguished audience who have all taken out time from their busy work and, of course, leisure hours to be part of this session. So, friends, just like when we argue a matter in the court, we need to know the facts first and then the law. So, while preparing for this session, we realize that lawfare doctrine discussion cannot center just around the law. It must center around some technology suggestions too, to make it complete for reference and understanding of the subject. So this will be our endeavor for today. Let me start by explaining the various expressions which have been used by us in the title of the session. I will take it further from where Ranjana ji just left it. So, well, the first ingredient which is mentioned in the title is artificial intelligence, which we will call AI now. We really do not need to spend much time on an introduction to AI. All I need to say is that the concept of AI has captured human imagination for a long time. But it is only in this century in which we are living that AI has truly emerged as a powerful technology of wide application. Current generation AI has surpassed human ability in relation to a wide range of tasks and is slowly making way in our day-to-day life. So therefore, the concerns have also arisen which need to be addressed. Now, friends, the next expression which is used in the title you would have seen is a kill switch. This would require a bit of a more detailed introduction than I gave for AI. I will start by giving you two real examples, making the point concrete. The first example is that of chips and models. So we all know that most of our gadgets, most of our software tools, most of our cars are now based on chips and models. In January 2025, the United States, for the first time, placed some control on the export, not only on the advanced chips, but also on the weights of the most powerful AI models themselves. Now, what are the weights? Weights are the numbers that make a model intelligent. The rule of the US government sorted the whole world into tiers and layers. Many ordinary countries were treated as second class, with caps on how much computing power they could receive. That particular rule, although was withdrawn in May 2025, after there was an industry pushback, of course, but the underlying tool, that is, who gets the access to the control, is now a permanent feature of United States policy and keeps being rewritten. Now, the second and more recent, and which all of us should know, what has prompted this session, in fact, is the Fable 5 episode, where the United States government effectively forced an American AI company to shut off a service worldwide. This showed in the clearest possible way what dependence on a foreign provider can cost. So one foreign government directive and the service has gone everywhere, shut down. Now, to understand this, I must place some more facts on the recent Fable 5 shutdown so that all of us can appreciate what is the genesis of the problem, which we need to discuss and deliberate upon, and then come to the legal regime within which we must keep this discussion. So the showdown over Mythos 5 and Fable 5 marked the latest clash between a company called Anthropic and the US government. Now, from what we know, there was an ongoing dispute between the company Anthropic and the US government over military use of Anthropic's AI tools, which the government had to buy. So after the contract talks broke down, the Defense Department of the US government, it seems, declared the firm a supply chain risk in March. Now, what has happened in the interregnum? In the interregnum, Anthropic had expanded its restricted project, which is called the Glasswing program, to our country, India, in early June this year. What was done? Indian organizations were given access to the Mythos 5, which is a version of Fable 5, which I just mentioned, as a preview model for cybersecurity testing. So India was made one of the earliest countries to receive access to Fable 5 or say Glasswing program of Mythos. Now, days later, the US government export control directive came, which I just mentioned. What did it require? It required Anthropic to disable both Mythos 5 and the public-facing Fable 5 for users worldwide, including in India, after the US government said that it had learned of a possible jailbreak of the model, which it treated as a security threat. Now, Anthropic had no choice. It quickly complied with the US government order, saying that it could not reliably distinguish foreign nationals from other users in order to comply with the directive in any other way. So it was a blanket sort of shutdown by Anthropic. Fable 5 was prevented from responding to certain types of queries. Now, let me just explain. All of us use some kind of AI now. So if you would write a question on, say, Meta WhatsApp or Google Gemini, it would generate an answer. So it works in that sphere. So Fable 5 was prevented from responding to certain types of queries, including those related to cybersecurity and biology. In those cases, so Anthropic said in an official statement that its Claude chatbot will route responses through a different model, which is called Opus 4.8. Now, what happened? About 200 firms already had access to Mythos through this program. And those firms included Apple, Alphabet, Google, Cisco, NVIDIA, and Microsoft Corp, etc. So all of them were being used by users worldwide. So now please see the mechanism, which is the most important aspect. The tool used here was neither a tariff, nor it was in the sanction list of the US government. It was just a domestic export control directive, which is a piece of American administrative law operating within America's own statutory framework, which reached across borders and disabled a commercial service almost overnight. Now, of course, just to complete these facts of the second example, good news is that the tension as of now seems to have eased. The confrontation which has erupted some weeks ago between Anthropic and the US government has eased down. My team tells me that the USA government has assured India that technology access, once granted, will not be abruptly withdrawn in future. This commitment was conveyed by the US officials during talks with India, according to our IT Secretary, Shri S. Krishnan. Now, when did this happen? This was during a recent Mr. Krishnan and Mr. Helberg meeting, which recently took place on the sidelines. There is a second Pax Silica Summit in the US. So there these talks have materialized. And to quote unquote Mr. Krishnan, because this is very relevant for today's lecture, what Mr. Krishnan has said, as per a newspaper report which we found out, we sought an understanding of how exactly the US is looking at this particular aspect and what their concerns are, and how in the future this could be a reliable source of technology. Because if it is something which is to be used and made available, we can't have abrupt cutoffs. We were given an understanding of how the US looks at this particular issue and how going forward they will ensure that for trusted partners, access will not be an issue, said Mr. Krishnan on the sidelines of the second Pax Silica conference in the US. So now, friends, this communication, this statement by our secretary, Mr. Krishnan, says a lot about our today's session. In short, just to understand, one foreign government order against an artificial intelligence company based in that country and a global service goes dark. An Indian hospital, an Indian court, or a business loses a tool it had built its work around. Your Gmail or WhatsApp can also be shut down. Airline operations can come to an abrupt halt. That is the scale of digital devastation it may entail. That is our over-dependence on foreign software. Consequences, well, are for anyone to imagine. So the extent of how much we are all dependent today for our day-to-day life on the internal policies of a foreign territory where the companies we use are situated, and which of course are beyond our borders and beyond our legal control, defines the magnitude of the problem. And I urge that all of us have to be future ready in this regard. Now, the next expression used in our subject title for today is the fancy word lawfare. Now, to our mind, lawfare is an innovative word which we must get used to very soon in life. It is derived from law and warfare. So just like we got WhatsApp once, which was probably something for WhatsApp group, similarly, we have now got lawfare. So therefore, now to merge the two, foreign law kill switch plus AI lawfare is basically what? It basically is, can a foreign government or a foreign company remotely sitting in their territory disable, cripple, or manipulate the AI systems which they own but they run in India? And if they do so, what is India's legal and strategic response? So friends, after this technical introduction, let us try and delve a little deeper into the problem vis-a-vis our session subject for today. So what happened with Anthropic on June 12 this year is best understood to explain what is lawfare. The use of legal instruments to achieve strategic ends that once required harder tools. Globalization was often presented as a political infrastructure with capital, goods, and code flowing beyond the reach of anyone's sovereign. The actual geopolitical conventional warfare story, now it seems, was also always incomplete. What happens after the intermission? That was pre-intermission. What happens post the intermission is that the real choke points of the digital economy have become advanced semiconductors, frontier AI models, cloud infrastructure. Most of us use cloud, payment rails, and technical standards. All of them sit physically and legally within a small number of jurisdictions. Like I said, the US, some countries in Europe, maybe China and Japan. Whoever controls the jurisdiction controls the off switch. All of us use cloud. Now, while preparing this lecture, we realized that there is a US Cloud Act, which can always compel sharing of data with their government, that is the US government, unless perhaps if you are on an enterprise contractual version of the same. We'll touch that upon later in our lecture. So there is a data privacy side issue as well, not to be covered today, but there is a side issue. So the real problem is this. Almost every powerful artificial intelligence system used in India today is built, owned, or controlled by someone abroad, mostly in the United States. So the advanced chips come from American companies. The most capable models are made by American firms. The cloud computers that run them sit on contracts written under American or European law. India is a very large user of this technology, but it makes very little of the top-end version itself. Now, what does this do? It creates a sure vulnerability. If a foreign government or even a foreign company acting under its own government's orders, which are perfectly legal and justified in their context, decides to switch something off or restrict it or change the rules, an Indian user can lose access overnight. The Indian user did nothing wrong. The decision was taken in another country, under another country's law, and maybe validly. But there is no Indian court or Indian rule to turn to for help for the Indian user. Now, this is what this lecture means, understands, and calls a kill switch. It is foreign law reaching in and disabling something which India and its citizens depend upon. So, to this problem, what should be our response? Our response, our country's response, India's response has to be legal as also technological. Therefore, at the outset, I said that after law, we also need to talk about technology a little bit, which we will do. So this Anthropic episode demonstrates that globalization now runs not only on infrastructure and markets, but on law. Thus, India needs a lawfare doctrine, not merely a sovereign AI strategy. That is my emphatic discussion on this platform. We do need a lawfare doctrine. Now, lawfare means using law and legal process as a weapon or a tool of pressure instead of or alongside conventional force. So the question for this lecture to be answered not only by me but all of you together is whether foreign legal systems are being used in a way that can quietly control or choke India's access to AI, and whether India has any answer ready. Secondly, does India need a formal, thought out, and legal strategic posture, a doctrine to anticipate and resist this foreign legal leverage in future? This tension, friends, is the heart of this lecture. So now that we've discussed the three expressions which have been used in our today's title, because most of us may be knowing it, but some audience may not be aware. Therefore, we endeavor to do that. Now let us get along with the core subject matter. So let me start with some reality check. As a country, we face several challenges in protecting our AI ecosystem from foreign legal and technological control. The challenges are: India is still heavily dependent on foreign technology for advanced AI, especially chips, cloud infrastructure, foundation models, software tools, and app distribution platforms. Foreign laws such as export controls, sanctions, data transfer restrictions, copyright claims, AI safety rules can indirectly affect Indian companies even when the activity is taking place in India. We yet do not have a comprehensive AI specific law. There are some laws, we will cover it in later part. So the response is scattered across different laws and regulators. Common men may not even know. India lacks sufficient domestic compute capacity and advanced semiconductor manufacturing, which makes its AI ambitions vulnerable to external restrictions. Now, most of us would be lawyers in this audience. I just want to build up a case with all of you, with the government and with our courts of law, why we need an AI lawfare. We need an AI lawfare because of the following proposition as per me and my team. 1. Dependency is high. Most Indian startups, government pilot projects, banks run on foreign foundation models, foreign clouds. So when there is a conflict situation in future, that's a single point of failure. Everything comes to an abrupt halt. Point B, data plus sovereignty. So if your legal AI, UPI fraud detection, or defense AI runs on foreign infra, a kill switch is a national security risk or disaster, I should say. C, counter pressure. US uses AI export controls. China uses great firewall plus domestic AI. If India doesn't have an AI lawfare doctrine, we are only reacting. We are not shaping rules. Coming back to the Anthropic fable mythos access suspension as a case study, this session must examine as to how such orders can affect Indian users infrastructure, companies, and public institutions. And let me assure you, we have tried to cover that too later in this session. It will affect the AI users among us lawyers too. So all of us have to be alive to the situation and we have to be future ready. The core legal question which would arise for our contemplation and deliberation is, when a foreign government directs a technology provider to cut off or restrict services used in India, should that command have practical effect without a review provided under the Indian law? Now, one set of argument by some people, some of them are industrialists, which we found out on the website, is that Indian institutions ought to rely more heavily on domestic and open source models rather than foreign frontier systems. Now, that argument, no doubt, is persuasive, but it captures only half the problem, only half the exposure. The other half is for all of us to cure, and that is jurisdictional and legal, and we all need to work together. We need to give representation to the government and to the courts of law. And that is a problem first for us lawyers and policymakers. And second, for the engineers. It is first a primary problem for us as lawyers, as my audience here. Next, the geopolitical layer is not the only factor. There is a private law layer too. So again, coming back to lawyers, which can be called the everyday switch, in fact, the everyday kill switch. What does this include? These include foreign governed terms of service, cloud contracts under United States or European law and foreign courts, unilateral vendor termination, etc. This affects far more Indian users than any other geopolitical event. So it's a digital event, affects us more. So friends, India should do what? India should ensure by enacting appropriate laws and policies that its AI systems cannot be controlled, disabled, or unfairly restricted by foreign laws or foreign companies. We need a clear legal and policy framework to protect our AI independence while still allowing Indian companies to work with the global ecosystem. So for India, the policy conclusion cannot merely be that we should build our own models, though we should. It is that technological self-reliance without a corresponding legal doctrine, I repeat, without a corresponding legal doctrine, which is an incomplete shield. So we know we need to go for the complete shield. Now let's come to the next point, which is as to till date, what have we done? What have we achieved? It is not a hopeless situation. I'll tell you what we have achieved. So India's current legal regime can handle some AI related issues. But friends, it is not yet sufficient to handle the larger foreign law as a kill switch problem, which is at the heart of today's session. Not that we are not doing anything, but we are not building a US style dominate artificial intelligence lawfare doctrine. What we are doing AI for all plus something called DPI, which is digital public infrastructure. We have several achievements. We have Aadhaar, we have UPI, we have something called ONDC, which is Open Network for Digital Commerce. These are all kill switch resistant. Why? Because the code as also data are largely, if not completely, Indian controlled. Then we have Bharat Gen, we have Sarvam, we have Krutrim. These are all indigenous LLMs and they reduce model dependency risk. Now coming to something very important. We have Digital Personal Data Protection Act 2023. It is popularly called the DPDP Act 2023. It gives government a large amount of power to block foreign data flows in the interest of sovereignty. However, to our understanding, my team and I have worked on this. To our understanding, the ministry has notified 3 sets of dates, 14/11/25, which has gone, 14/11/26, and 14 May 27, for the enforcement of different provisions of the DPDP Act, along with the corresponding rules. So the substantive provisions, nonetheless, of this Act and the corresponding rules will come into force on the last date, which is 14 May 2027. We still don't have it in place. Now, this Act does what? It gives India a modern framework for digital personal data. It recognizes individual privacy and the need to process data for lawful purposes. But there is a catch. We've examined the DPDP Act. In all fairness, it is mainly a data protection law. It is not a comprehensive AI sovereignty or AI safety law or part of Lawfare Doctrine. So what we have done, we have chosen a deliberately light touch. Rather than passing a heavy AI law, we released the India AI governance guidelines. This is the second set which we've been able to find out, built on the idea of using existing laws wherever possible and not over-regulating a fast-moving field. Now, at the same time, we are trying to build our own strength. So the India AI mission has put tens of thousands of what they call GPUs, graphic processing units, into the country, funded homegrown models such as Sarvam, and built Indian datasets. But what happens? All these datasets are built around chips which are still foreign designed. So India is reducing its dependence, but not removing it. Now, I want to come back to the just mentioned India AI governance guidelines because that's important. They are circulated by MeitY, which is the Ministry of Electronics and Information Technology. Now, having gone through the same in some detail, we find that the focus of these guidelines is on data protection, copyright, deepfakes, Information Technology Act, digital public infrastructure, capacity building, content authentication, and that's all. Now, unless we are all mistaken, we were not able to find any foresight or discussion on AI lawfare or kill switch situations. Now, next part of what we have done, closer home, and our lawyers in the audience will relate to it. Our Honorable Supreme Court of India has taken a significant initiative by recently publishing the draft regulations. Now, these are called Regulations for Use of Artificial Intelligence in Courts 2026. The Honorable Court has also invited comments and suggestions from stakeholders and the public. And on the various Supreme Court groups, I find very, very constructive discussions on these issues. Our Mr. Virag Gupta is the leading propounder, and I'm sure he will give very good suggestions. Both the associations, SCB and SCORE, are also working towards it. Now, what do I suggest by way of this lecture? I suggest that we must pose a larger question to the Honorable Court and give suggestions accordingly. So, for example, if tomorrow there is something called AWS, Amazon Web Services, were to suspend the server hosting the Supreme Court's e-filing system itself because a US sanction order has changed the situation overnight, what is the remedy? Now, I was told that in that regard, there may not be anything to worry because we have something called the enterprise model, the business model, which perhaps will save the situation for the Supreme Court. But any other subscriber can still suffer. Even a subscriber can still suffer if it's not an enterprise model, so to say, which of course will cost much more than a subscription. That really is the foreign law kill switch problem, which will relate to and affect us lawyers as a class and the courts and the justice dispensation system as a whole. So I must tell you something very interesting. It is both a data sharing problem and a kill switch problem. A team member, while we were preparing for this lecture, Divyanshu, he informed me that now in US courts, when you make search for answers on Claude or any other recognized search engine, and somebody who is doing this research is an accused later in an offense, so these searches made by him are being treated as admissible evidence to prove the offense which is purported to have been committed by him or her. Now, there is a likelihood even further that he doesn't make this research. When his matter goes to a lawyer, the search is made by his lawyer based on the information received by his client, which is the accused, while preparing the case, and the lawyer happens to use any AI tool or a search engine like Claude or Google or any AI tool, any recognized AI tool. That I am told may also be treated tomorrow as admissible evidence against the accused. So data protection regulations are not of much help in this regard. Now, we can quote a similar instance, the recent unfortunate demise of a man in India who fell from a fort. All of us heard on TV that the investigating agencies using Google search history of the accused to assess their alleged conspiracy and preparation. So my friends, the lawyers in this audience, you are using AI for court work and also for the public at large. You all need to be careful as all these tools are hosted outside India. So there will be a data problem, and tomorrow there can be a law which will put you against the wall for the search which you have made. Now, coming back to the Supreme Court regulations, we feel that there are some regulations which give us a sense and flavor that court does have in mind the lawfare, but maybe not exactly so. So when we give our suggestions, I urge SCB and Scora, all my other friends who are going to give individual basis objections, that we must point this out. Now, few regulations, for paucity of time, I'll not mention everything. Regulation 3 bracket ZH of the proposed Supreme Court regulations. What are they? They are the sensitive judicial data. They define sensitive judicial data to include any personal identifiable information of parties, witnesses, or legal representatives, and any information processed in connection with the court process, the unauthorized disclosure of which may cause harm. So a lawyer using an AI tool to prepare a matter will fill the details of his client. He may even fill, if it's a criminal matter, as to what the client did or what he did not do. All of this will get hosted in a server which is outside the territory of India. It can be used against you or him. Next regulation is Regulation 19, which is worth a mention, is permissible uses of AI and includes significant data which is prone to sharing. So that says it all. We may unknowingly be sharing all such data to foreign hosts at the cost of repetition, particularly if we are not into enterprise and highly paid versions of those softwares. Now, there is a Regulation 23 in the Supreme Court regulations, which is functions of the apex body. So my suggestion through this session is that it should include consultation with the government of India, not only on the subjects mentioned in the functions of the apex body, but also regarding our session today, which is the AI lawfare, not restricting its power just with respect to use of AI in the Indian courts, which is sub-regulation F, I think, of Regulation 23. Now, the next regulation relevant for today's discussion is Chapter 7 of the regulations, which provides for data protection and cybersecurity. Now, they use an expression called external system. So just like I said that Supreme Court seems to be in season of this lawfare, may not be in exact terms. So there is this expression called external system, which is mentioned in Regulation 48, which is defined in Regulation 3X. Now, what does external system mean as per these proposed regulations? It means any computing infrastructure, server, software platform or network not owned, managed or directly controlled by the court or the appropriate authority. So the AI tools used by lawyers need to be used very carefully to avoid data sharing with foreign hosts and to avoid a kill switch situation. You put all your data on a server, tomorrow administration of the US says kill switch, your data is gone. So these are perhaps the safeguards which we need to discuss while suggesting a legal framework for use of AI tools. Now, I wanted to mention, I was not sure whether it applies, but I think it needs a mention in a recent judgment regarding the NEET examination. All of you would know, Telegram was blocked by the government of India and the decision was challenged in the Honorable High Court. So Justice Tejas Karya, based on interpretation of Section 69A of the Information Technology Act, observed that mirror is kind of a carbon copy. So mirror channels, reserve channels, and audience migration mechanisms had repeatedly undermined entity-specific interventions. The Honorable Court accepted the government's reasoning that narrower measures had proved ineffective. It also regarded the message editing feature as particularly significant because it could be exploited to create false impressions that examination papers had been leaked before the examination. Now, this is what the government says that happened. Nonetheless, what did it do? It led to a re-exam of 23 lakh NEET aspirants. So the Honorable High Court, in its judgment speaking through Justice Tejas Karya, took note of Telegram CEO's public acknowledgement of both the scale of misuse and the inadequacy of the edited label and treated it as a concession. I repeat, the Telegram CEO's public acknowledgement was used for the judgment. So this judgment is a forward step. See, what we have discussed today is in fact a reverse situation. Come to think of it. In that sense, the government and the courts must have the power to unblock also. So in this judgment of Telegram, the Honorable Delhi High Court upholds the government's decision to block. Telegram is also based outside. It is not based in India. But the power to block it was exercised and upheld by the Indian courts. So the reverse power to unblock should also be extended by the government to itself, and the court, of course, should have the power to uphold it. Now, next set, what we have done is a statute called the Information Technology Act, which is vintage now, 2000, and the rules. But they can also address intermediaries, platforms, cyber incidents, unlawful content, and certain online harms. They were not designed for foundation models. Perhaps it was not in the contemplation of the legislature in the year 2000 about AI lawfare. Autonomous AI agents may also be covered. Some compute dependencies covered, model governance, algorithmic accountability. But what is not covered is foreign regulatory coercion, which is the kill switch. So our legislature needs to look into it. Some silver lining, some sectoral regulators, and which are important, such as RBI, SEBI, IRDI, TRAI, health regulators, election authorities, they must regulate AI within their own domains. Now imagine a bank, a hospital, a school, an edutech company, an insurance company, social media platforms. They are all part of our day-to-day lives. They may all face different tools without a common national AI standard. So we need to have a common AI national standard. Although the silver lining which I mentioned is, our research says that Reserve Bank of India is doing a phenomenal job. It is the front runner and the fastest runner, and it is doing a lot in terms of AI lawfare. So now, friends, what is the next part of this session? Next part is enough moralization done for the government. We should give some suggestions. There are some suggestions which we've been able to think of. All of you are also free to give your suggestions to the government because it is very, very important. You can, I would go to the extent of saying that we can work around in a PIL jurisdiction also. So what should India do more in addition to what we have already done, what I just explained, as part of AI lawfare? So the first thing which comes to my mind is, and there is a slight mention of that in the MeitY regulations, there should be something like an artificial intelligence diplomacy policy. That would be very relevant for issues highlighted in today's session. Global diplomacy on AI governance is indeed touched in the MeitY's regulations, like I said, but the same may be considered for expansion to include what we have discussed. Next, we should create a legal and policy framework that ensures that critical Indian AI systems cannot be suddenly disabled. Now we'll come to the distinction. There can be a critical, there can be not so critical sort of ecosystem where AI works. So the critical Indian AI systems should not be suddenly disabled, restricted, or controlled through foreign laws, foreign vendors, or foreign infrastructure. What does it mean? It means that we must build domestic fallback capacity. We must require transparency from foreign AI providers. We must regulate high-risk AI use in India. We must protect Indian data and ensure that foreign legal orders do not automatically override Indian public interest, security, or constitutional rights. Now, there is a lot of work already being done by the government in these spheres. I'm not saying that we are not doing anything or that it is a near disaster situation already. But we need to work specifically and we need to make our laws compliant with this. We need to have acts and rules which should take care of this situation if it were to happen in future. Now, the next suggestion by me and my team, India should create a national AI law or AI governance code, like I just mentioned. What does that law require to do? It should not only regulate every AI tool in the same manner, it should rather follow a risk-based model, like I said, critical, non-critical. So there can be a light touch regulation for ordinary AI tools, but stricter rules for high-risk AI, such as in banking, health, education, policing, defense, courts, elections, critical infrastructure like railway, public administration, airlines, power grids, etc. And all of these should have mandatory human override what I've been told is called something called an audit trail. Indian grievance mechanisms should be in place. There should be defined cyber security standards and continuity plans. Suggestion number 4. Indian law should impose vendor risk obligations on foreign AI providers operating in India. So if a foreign model, cloud provider or platform is used in critical sectors, Indian law should require disclosure of data flows, service continuity obligations, local escalation officers, audit cooperation, and notice before withdrawal or suspension of services. Suggestion 5. Indian law should create a limited blocking stroke sovereignty mechanism for foreign legal orders. Say, for example, if a foreign law or a court order requires an AI provider to disable a service in India, which happened in the Anthropic example, or deny model access, or remove Indian data sets, or restrict Indian users, what should we do? The law should provide that the matter should be reviewable by an Indian authority where public interest or national security is affected. So at least that part of the regulatory order should be allowed to be reviewed by an Indian authority. Suggestion 6. Indian law should build litigation and trade law capacity. AI disputes will arise where? They will arise around export controls. Export controls means the US government can say that you will not export your AI access to India. That's the export control mentioned here. Sanctions, copyright, data protection, platform access, discriminatory denial of service, competition abuse, standard setting, so on and so forth. So we need a coordinated legal strategy before the World Trade Organization forums, the domestic courts, the competition regulators, and international standard setting bodies. What should be our next coverage point? Suggestion 7. The next coverage point is resilience, retaliation, deterrence. So there needs to be a legal framework in place to penalize foreign firms that arbitrarily cut service without Indian legal due process. Serial 8. Do not allow software companies like AWS, Azure, OpenAI, etc. Many of us are aware of all these companies to terminate or block access, that too without sufficient notice. So the number of Indian users is staggering. If our research is correct, more than 10 million, I am told, are already using AI. So arbitrary termination or blocking affects the right to livelihood and even access to justice and other day-to-day facilities, such as we mentioned, aviation, healthcare, education. So our courts, I would go to the extent of saying, may even consider invoking Articles 14 and 21. Call upon the government. Why has this happened? Why do you not have a treaty or a reciprocal document with the company which is being used in India? We already have some framework in the DPDP Act, like we mentioned, which can be adopted under the IT Act to enable AI specific protection, but it will need a lot of work. And I'm sure that work is going on somewhere, but it will need a lot of work. The suggestion number 9 is the IT Act, the Information Technology Act, may be amended to include significant AI service provider. Now that's a quote unquote in italics, significant AI service provider, because there is already an existing sort of concept which is defined in this act, which is significant social media intermediary. So that will have reference to Section 79 IT Act and the 2021 rules. Suggestion number 10. Law should provide at least for 90 days written notice. See, there may be a case where there is a valid shut-off required, valid shutdown or kill switch, whatever you may call it. That law should provide for a 90 days written notice to the foreign entity. The reasoned order is a must, and there has to be an appellate remedy. So there has to be an appellate authority in place which can consider what's going on. Penalty provisions, like I said, need to be incorporated. Now, suggestion number 11. We have gone through the DP Act, which is the Digital Personal Data, Section 711. So the government under these sections can separately consider notifying critical personal data, which will have to be defined, of course, to be mandatorily stored or processed in India so that we have control on it. And like I said, we are told RBI has already done it for payments within the country. So every other organization should then take it up. Suggestion 12. Coming to the honorable courts now, where all of us go every day. Courts need to direct the government, if not already done, to notify critical AI systems under the 2023 Act. And this is the suggestion which we must give in response to the draft regulations, which the Honorable Supreme Court has painstakingly taken out. So I will repeat. The court should direct the government to notify critical AI systems under the 2023 Act, such as our e-filing in the courts, including the Supreme Court, Nalsa AI, Ayushman Bharat, which is so critical to the health infrastructure. The mandate must be to have real-time mirror in India. So what is a mirror? Mirror is a carbon copy of the data and the servers and Indian backup model. If there is no mirror being provided by the company, there should be no license to operate in India. So it will need a synced and a coordinated effort between the courts, between all of us and the government. Our next suggestion, Serial 13, Disaster Management Act, Telegraph Act, Telecom Act, etc., in addition to DPDP and the Information Technology Act, they all need to be suitably amended to take care of the exigencies which we are discussing today in this session. Serial 14, if not all, then at least significant AI providers should have AI grievance officers, should have nodal officers in our country bound by its territorial laws with power to receive legal notice and communication and to comply with the orders. And Indian court should have power to enforce these orders upon those offices and upon those officers. Suggestion 15, government and courts need to emphasize on foreign AI providers. Simple. If you can do business with us, 1.40 billion Indians, Articles 14, 19, 21 of the Constitution, even 32, I would say, would travel with you, brother. You can't be divorced from these articles. You have no immunity. Suggestion 16, India should develop public procurement rules for AI. Government department should not procure black box AI systems without contractual rights to audit, test, suspend, explain, localize, and migrate the system. The state should avoid being logged into one foreign AI provider. There should not be any monopoly. So now let's come to the summary. A serious Indian lawfare doctrine would contain 4 elements. The first is defensive insulation. So like I said, we have the DPDP Act and the IT rules, but we don't have an equivalent instrument addressing the question raised by the Anthropic episode. When a foreign government directs a company to alter conduct affecting Indian users, what status does that directive possess within Indian law? We must answer that. I have to leave you with this question. Because at present, the answer is unclear. That uncertainty in itself defines our vulnerability. So India does not need a sweeping or a confrontational blocking regime, but it does require a narrowly tailored framework establishing that foreign legal commands affecting Indian users, Indian infrastructure, or Indian commercial rights do not automatically acquire force within India. They must first be tested against Indian law. The second requirement is redundancy. It needs to eliminate single points of failure. Redundancy is a problem. The third element is leverage. So the lawfare is not only defensive. Our domestic market in itself is a source of jurisdictional power. We have immense purchase capacity. Any platform operating here must accept Indian law as the price of its entry here. Reciprocity should therefore become part of regulatory thinking. Market access cannot mean that Indian users remain exposed to abrupt service withdrawal because another government changes its mind and changes its administrative position overnight. Fourth element, forum dimension. So trade law, investment treaties, WTO, emerging technology governance arrangements, they are not side stages. They are arenas in which legal arguments frequently substitute for harder forms of pressure. India already understands this logic in other domains. The challenge is to bring the same seriousness to technology, data, and AI governance, where our posture has too often been reactive rather than strategic. So we need to change that. The question is not whether India can build everything itself, because it cannot yet. That's unfortunate. But whether it walks into dependence with its eyes open and a legal strategy in hand. That's the problem. So to conclude, India may not need only a sovereign AI capability, but a legal doctrine that prevents essential digital access from depending entirely on another country's administrative discretion. Or maybe, if I can say so, we should work towards soon becoming Atmanirbhar and Viksit in the field of AI as well. So that, friends, concludes my session. However, before I part with my session, I wish to thank my legal techno team who have helped me develop this session in record time. We had very little time. We had enough to research. So advocates Aditya Kashyap, Karthike, Bhaskar, Arkaj Kumar, Abhinay, Divyanshu Rai, Roli Shukla, Nikhil Jain, Ranjana Singh and Jyotin Tiwari, and my engineer son Swayam. All of us have worked overtime, and without their valuable contribution, today's session would have been incomplete, to say the least. So I also wish to thank Verdictum. I saw that Verdictum is the part of this event. Perhaps they are the sponsors or something. And now, just to conclude, it's been a very serious session, so I want to conclude it with a lighter vein. The lighter vein is in the spirit of compliance with draft regulations by the Supreme Court of India, being Regulation 43. My team and I must disclose the contribution of not only the aforementioned team members, but also Meta, Claude, WhatsApp, Google Gemini, and all others, which we have used for this session. And all of us sitting here, we also thank our stars that these tools were not switch killed during our preparation and during this session. On that note, thank you very much. Namaskar. Over to you, Aditya, Jyoti, and Ranjana.
Thank you, sir. We are immensely grateful for your efforts in finally articulating on the very critical areas and nuances of today's topic, which has led to the insightful and engaging session today, sir. So your thoughts and suggestions on this topic have certainly left us with so much to reflect upon in order to navigate through this critical and intricate issue. Now we have reached, and I again extremely I show my gratitude and thanking you, sir, for this insightful lecture. Thank you, sir. Now we have reached to the concluding part of today's session. I would now request Astha ji to kindly deliver the vote of thanks and conclude today's session with concluding mantra. Over to you.
Thank you, Ranjana ma'am. सबसे पहले आदरणीय मुख्य वक्ता श्री गगन जी को मैं आभार प्रकट करना चाहती हूँ। अधिवक्ता परिषद के प्रमुख कार्यकर्ता एवं इस ऑनलाइन लेक्चर में जुड़े सभी पार्टिसिपेंट एंड लिसनर को मेरा नमस्कार। मैं आस्था आर्या, अधिवक्ता परिषद सुप्रीम कोर्ट यूनिट की कार्यकर्ता हूँ। अधिवक्ता परिषद सुप्रीम कोर्ट यूनिट द्वारा आयोजित जस्टिस एस परवता राव लेक्चर सीरीज के इस 4th सेशन में संपन्न होने के समय मुझे वोट ऑफ थैंक्स देने का सौभाग्य प्राप्त हुआ। इसके लिए मुझे अत्यंत गर्व हो रहा है। आगे बढ़ते हुए सबसे पहले मैं आज के प्रमुख हमारे मुख्य वक्ता सुप्रीम कोर्ट के सीनियर एडवोकेट माननीय श्री गगन जी गुप्ता का हार्दिक अभिनंदन करती हूं और आभार व्यक्त करती हूं। सर, आज आपने जिस गंभीर और दूरदर्शी टॉपिक फॉरेन लॉ एज ए किल स्विच, डज इंडिया नीड एन एआई लॉफेयर डॉक्ट्राइन पे अपने विचार को साझा किया है, इससे हमारे सोच का दायरा काफी बढ़ गया है। आपका यह लेक्चर काफी इंसाइटफुल था सर। लीगल फ्रेमवर्क, एआई लॉ नेशन वाइड का इम्प्लीमेंटेशन, 19 डेज के टाइम लिमिट में नोटिस का रिप्लाई, हाउ टू यूज एआई इन द लॉ सेशन, यह सारी नॉलेज हमें प्राप्त हुई। आपका बहुमूल्य समय देने के लिए आपका बहुत बहुत धन्यवाद सर।
थैंक यू।
मैं अधिवक्ता परिषद की पूरी एग्जीक्यूटिव टीम और ऑर्गेनाइजिंग टीम के प्रति भी कृतज्ञता व्यक्त करना चाहूंगी। उनके सफल प्रयास से ही ये वेबिनार आयोजित हो चुका है और इतना अच्छा विजन जो कि लोगों के बीचों में नॉलेज को बढ़ाए, इंसाइटफुल थॉट्स लाए, इसका आयोजन कर सके हैं। इसके बाद में यूट्यूब के माध्यम से जुड़े हुए सभी हमारे व्यूअर्स, एडवोकेट्स और लॉ स्टूडेंट का भी धन्यवाद करती हूँ। साथ ही साथ मैं स्पेशल थैंक्स टेक्निकल टीम को देना चाहती हूँ जिन्होंने वर्चुअल सेशन को संचारी रूप से संचालित किया है। आप सभी का बहुत बहुत धन्यवाद यह वेबिनार को सफलतापूर्वक आयोजित करने के लिए। अंत में मैं एक श्लोक बोल के अपना वोट ऑफ थैंक्स खत्म करना चाहूंगी। सर्वे भवन्तु सुखिना, सर्वे सन्तु निर्मम्या, सर्वे भद्राणि पश्यन्तु, मा कदाचित दुख भाग्य भवेत्। अर्थात सभी सुखी हो, सभी रोग मुक्त रहे, सभी का कल्याण हो और कोई भी दुख का भागी ना बने। जय हिंद, जय भारत।
Jai Hind.
Thank you everyone for joining us from various locations online. And with this, we have reached to the concluding point of our today's online session. I again thank you, sir. Thank you for coming. And
Thank you.
I thank all our audience for making this session a success. Thank you, everyone.